Dear friends, welcome to the channel. Today I am going to discuss two important case laws pertaining to the issue of the remand of the inquiry. We have discussed in many cases that the courts or the tribunals interfere into departmental proceeding matters only on limited grounds, such as the High Court or the tribunal set up under the Administrative Tribunal Act would interfere only when it is pointed out that the departmental proceedings were vitiated on account of procedural illegality or on account of violation of the principles of natural justice. Now, we will take example of a government servant working with the government of India and governed by the civil service rules, that is CCS, discipline and appeal rules, or CCA rules, that is classification and conduct and appeal rules, etc. Dear friends, these rules lay down the entire procedure in case of departmental inquiry and also provides penalties to be imposed on the government servant and also lays down the procedure which would be in compliance with the mandate of article 311.2, because 311.2 says that the employee cannot be punished with the major penalties like dismissal, removal, or compulsory retirement from service, or even reduction into rank, unless he is afforded an opportunity of defense in a full-fledged departmental inquiry. And that is how the departmental inquiry has to be conducted in the manner laid down in the CCA rules. And also, the principles of natural justice will have to be followed in true spirit and letter. Now, despite this being legal position, despite this being the legal mandate of Constitution of India as well as the CCS rules, often we come across the cases where the inquiry is vitiated because some principle of natural justice is violated or some of the procedure as laid down under the CCS CC rule is not followed, which also amounts to violation of natural justice or which shows that the authority acted with bias or prejudice in the mind, or the predetermined approach on the part of the disciplinary authority, etc. And in such cases, the courts under writ jurisdiction, that is High Court, and the tribunals under the the Administrative Tribunals Act would be entitled to interfere. Now, ultimately, what happens when it is ultimately proved in the court that the inquiry has been vitiated? What is the option left to the court? It has been long back held that in such cases where the inquiry proceedings are found to be defective on account of violation of natural justice or procedural violations, then an opportunity has to be afforded to the employer to rectify the error. That means the inquiry is to be remanded back and it is to be conducted either de novo or from the stage when the illegality crept in, that is the stage where the principle of natural justice was violated. Now, because of this long standing practice followed by the courts, it is very surprising that an inquiry which initiated 20 years ago, and after the conclusion thereof and departmental appeal, then tribunals, then High Court, and then Supreme Court, years together go on, sometimes more than 2 decades, 3 decades go on. In the meanwhile, it happens in many cases that the employee stands retired on account of superannuation, etc. Now, question is, after such a long time, whether inquiry is required to be remanded back. Now, in this regard, we would like to discuss two case laws. That is, one case is State Bank of Allahabad versus Krishna Tiwari. Now, this was the case where the inquiry was held initiated on account of procedural violations and natural justice violation. Matter ultimately reached Supreme Court. So Supreme Court was considering a question whether the inquiry is required to be remanded back. And this is, dear friends, one case which I found that is very hopeful. It gives a hope that remanding back is not the only option, because in that case Supreme Court says that inquiry may not be remanded back. For example, when charges became very old, there has been long gap of the time, and the employee might have retired, and in such cases, if the inquiry is again remanded back, then that itself would be unfair, unjust, and oppressive. Therefore, the court or the tribunal may exercise discretion of not remanding back the inquiry. Now, this is the one case which I come across quite often. The tribunals and the high courts blindly, I may, if use that word, that is as a course of action, even after the decades, remand the inquiries back, which result into unfairness and suppressive, as Supreme Court has held in the case of State Bank of Allahabad versus Krishna Narayan Tiwari. Now, recently I came across a case that was decided in last year, that is 2025. That is the case of State of UP versus Ram Prakash Singh. In this case, the employee was the concerned employee was, that is Ram Prakash Singh, was charged with a allegation that he misappropriated amount of 2.5 crore. This matter ultimately went up to Supreme Court, and Supreme Court held that although it is well settled that the inquiry has to be remanded back, but when the inquiry was initiated way back 2010 something, and now in 25, 15 years have gone, and the witnesses may not be available, which might have been available when the inquiry was held in 10, but now witnesses may not be available. So this was one of the extra reasons that was considered by the court for not remanding the inquiry back, despite the case being with such a serious allegation against the employee. Therefore, friends, and also this case is a new hope again, because apart from the case of State Bank of Allahabad versus this Tiwari, this is second case which I found in favor of the employee, because it doesn't happen that courts never hold that inquiry is vitiated because opportunity was not exercised by the employee to prove his case. Inquiry is never vitiated because the employee failed to defend himself effectively. But inquiry is held vitiated because management has failed to follow the law, failed to follow the principle of natural justice. Inquiry is never remanded back to give an opportunity to the employee to rectify his error or his mistake. So therefore, now these two cases which hold in favor of the employee's concern are very welcoming. And apart from this, I find one case from the Bombay High Court which has said that even if inquiry is to be remanded back, how many times inquiry is to be remanded back? For example, the employee is subjected to departmental action, he is dismissed or removed, or he's punished with a major penalty, and he challenges the same in the court, and ultimately court finds that inquiry is vitiated on account of violation of natural justice, and court decides to remand the inquiry back with a direction to conduct it again from the stage when it was found defective. Again employer commits the same mistake, or again doesn't follow the principle of natural justice, and again the same results into dismissal, removal, etc. punishment, and again employee concern will come to court, and then second time also court finds that inquiry is again initiated on account of the violation of natural justice. Second time question is whether inquiry is to be again remanded back. So Bombay High Court has answered this question negatively saying that the inquiry can be remanded back only once, and employer, if fails to rectify his error in that opportunity, then he may not be given second opportunity to rectify the mistake. That means in any case remand has to be only once, not repeatedly. And this is also one good case from Bombay High Court which decides in favor of the employee's concern. Otherwise, in the normal circumstances, even after fighting years together, what results is the remand of the inquiry. And in the case would be worst when without ordering back wages, without ordering reinstatement, when the inquiry is remanded back, it is worst scenario. And therefore, dear friends, I have been trying and I have been doing research in this regard to find to develop the legal position in favor of the employees, because ultimately it is not in the interest of anybody. Together, the enough time of the court is wasted. It is government which has to keep litigating. Employee will have to keep litigating, and the remand after remand, litigations after litigations, and ultimately the employee succeeds, then also he doesn't get justice, because for the whole the interregnum period of fighting in the court for years together, maybe several decades sometime, the entire family suffers, and ultimately what he gets is not a justice in true sense. Therefore, now the time has come that a line has to be drawn, and this remand syndrome has to be reconsidered. So, dear friends, with this today, I would like to say thank you. Today I came on after a long time, because nowadays I am not getting that much time because of the professional constraint. So, dear friends, now I will stop here. Thank you.